Thank you, dear students. Good morning to one and all. Today, handling for that contempt of court. So, you go to learn that page. It is very important for our department and our media related case issues. So, this is very important for our one of the topic. So, contempt of court. What do you mean, contempt of court? Meaning. What are the meaning and nature? It is very difficult to define the contempt of court. The contempt of court, what would often the dignity of the court and the lower of the court's prestige is a matter for the court to determine, and it cannot be confined within the four walls of a definition. So you just understand the four walls of a definition. This is complicated. And then the Contempt of Court Act in 1971 defined contempt of court for the first time. So in 1971, there is no definition of contempt of court. Whatever definition is provided under this act is not a definition, but only classification of the term contempt of court. Only the classification of the term contempt of court. Contempt of court in general means to offend the dignity of the court and lower the prestige of the court. So you just first understand these lines, double quoted lines, to offend the dignity of the court and lower the prestige of the court, lower the prestige of the court. This is the contempt. Thank you, dear students. Good morning to one and all. Today, handling for that contempt of court. So, you go to learn that page. It is very important for our department and our media related case issues. So, this is very important for our one of the topic. So, contempt of court. What do you mean, contempt of court? Meaning. What are the meaning and nature? It is very difficult to define the contempt of court. The contempt of court, what would often the dignity of the court and the lower of the court's prestige is a matter for the court to determine, and it cannot be confined within the four walls of a definition. So you just understand the four walls of a definition. This is complicated. And then the Contempt of Court Act in 1971 defined contempt of court for the first time. So in 1971, there is no definition of contempt of court. Whatever definition is provided under this act is not a definition, but only classification of the term contempt of court. Only the classification of the term contempt of court. Contempt of court in general means to offend the dignity of the court and lower the prestige of which is calculated to bring a court or judge. So, writing published, any act done or writing published which is calculated to bring a court or judge into contempt or lower his authority, or to interfere with the due course of justice or the lawful process of the court is contempt of court. Once again, I repeated for these lines: any act done or writing published which is calculated to bring a court or judge into contempt or lower his authority or to interfere with the due course of justice or the lawful process of the court is contempt of court. So you just understand first yourself, you just understand, and then you go to study with yourself. So, as per corpus juris scandal, as per corpus juris scandal, contempt of court is disobedience to court. Contempt of court is disobedience to court. So, what are the disobedience? So, you go to check with your link. I was explained for more and more explained for this related topic. It is very complicated for you. It is also simple and similarly you go to learn with your mother tongue by acting in opposition to the authority, justice, and dignity thereof. It signifies a willful disregard and disobedience of court's order. It also signifies such conduct as tends to bring the authority of the court, the administration of the law, into disrespect. So, into disrespect. So, as per according to corpus juris scandalum, contempt of court is disobedience to court by acting in opposition to the authority, justice, and dignity thereof. It signifies a willful disregard or disobedience of the court orders. It also signifies such conduct as tends to bring the authority of the court and the administration of law into disrespect. These things are very relevant for definition and some other codes. So we have a lot of definition libraries and books. So you just go to collect for your related definition. You just understand the contempt of court and classification. According to section 2, bracket in A of the Contempt of Court Act in 1971, contempt of court means civil contempt or criminal contempt. According to section 2, the Court of Contempt of Court Act 1971. 1971. 71. Contempt of court means civil contempt or criminal contempt. Section 2B of the Act defines civil contempt. What what it says? It says as willful disobedience to any judgment, degree, direction, order, writ, or other process of court, or willful breach of an undertaking given to a court. Section 2C of the Act defines criminal contempt as the publication, whether by words spoken or written, or by signs, or by visible representation, or otherwise, of any matter of the doing of any act whatsoever which so whether by words spoken or written or by sign or by visible representation or otherwise. So you just understand what are the act. sections. Section 2A, Section 2B, Section 2C says. What was say that? So it says civil contempt and criminal contempt. What are the civil contempt and the criminal contempt? How it is working? So do's or don'ts. You just go to read. So it's very important. Scandalizes are tends to scandalize or lower or tends to lower the authority of any court or prejudice or interferes or tends to interfere with the due course of any judicial proceedings or interferes or tends to interfere with obstructs or tends to obstruct the administration of justice in any other manner. So it's very important point. The definition contained in the Contempt of Court Act 1971 is not exhaustive. It merely indicates that the contempt may be civil contempt or criminal contempt. It is that better to leave it to the court to deal with each case as it comes and a right of appeal under section 19 of section the Contempt of Court Act 1971 in all cases of contempt will cure whatever defeat there may be in the application of the law. So there are several instances of the misconduct, such as using insulting language against the judge, suppressing the facts to obtain favorable order, imputation of partiality and unfairness against the judge. A counsel who advises his client to disobey the order of court is also held liable for contempt of court. Attacking the judiciary in the bar council's election is taken as contempt of court. If the council refuses to answer the question of the court, is also liable for contempt of court. In Re Ajay Kumar Pandey case, thus, for example, one case is here, one case study. So, Re Ajay Kumar Pandey case, the Supreme Court held that advocate using intemperate language against various judicial officials and attributing motives to them while discharging their judicial function would be held guilty of contempt of court. In this case, such advocate was sentenced or punished to a 4 month simple imprisonment and the fine of rupees 1,000. So, in this case, elaborate the what are the role of contempt of court? What are the against contempt of court? So you just civil contempt. So the purpose of the proceeding for civil contempt is not only to punish the contemptor, but also to exercise enforcement and obedience to the order of the court. In Vidyasagar, third additional district judge, Dehradun, 1991. It was held that civil contempt actually serves dual purposes. Vindication of the public interest by punishment of contemptuous conduct and goes on to compel the condemned to do what the court requires of him. To constitute civil contempt, the following are required to be provided. There is disobedience of the order, degree, etc., of the court or bench of undertaking given to the court, and disobedience or bench is willful, these requirements may be discussed as follows: disobedience of the order, degree, etc., of the court or branch of undertaking given to the court. For civil contempt, it is necessary that order which has been disobeyed must have been passed by the court having jurisdiction to pass order. If the order has been passed without jurisdiction, it is not binding on the party against which it has been passed, and therefore the disobedience such order will not amount to contempt of court. Further, the burden to prove that the court which has passed the order had no jurisdiction to pass it, or the proceeding in which undertaking was given was without jurisdiction, lies on the person who alleges it. In courts on its own motion, N.S. Kumar, 1995. In these cases, it was held that usually the order should be served on the person against whom it has been passed, however, where it is provided to the satisfaction of the court. The person against whom the order was passed had actual knowledge of the order, he cannot escape liability for contempt on the ground that the copy of the order has not been formally served on him. Once an order is made by the court and the person is charged with the allegation of non compliance of that order, he cannot plead that he was waiting for instruction to comply with the court's order can possibly contend that he is to seek instruction from his superior before he could carry out his obligation of complying with the court's order. The breach of undertaking given to the court is also taken as contempt if it is willful, where a person is committed for contempt of breach of undertaking. The undertaking must be given to the court. The undertaking given by one party to another is not sufficient for this purpose. An undertaking may be given by the party himself or by any other person on his behalf, provided in the latter case the person giving the undertaking has authority to give such undertaking. Thus, an undertaking may be given by an advocate on behalf of his client, provided he had authority on behalf of his client to give such undertaking. So these are all cases are very important for here. You go to read, you go to understand these lines, then only you got the particular right points. Okay, I wanted to tell you more points. The basis for taking the breach of undertaking as contempt of court is that contemptor, by making a false representation to the court, obtains a benefit for himself, and if he fails to honor the undertaking, he plays a serious fraud on the court itself, and thereby obstructs the course of justice and brings into disrepute the judicial institution. Judicial institution. In Babu Ram Gupta versus Sudhir Basi, 1979. Some other cases are here. I explained for that cases. The Supreme Court has made it clear that the breach of undertaking recorded or forming part of the comprises legal would not amount to contempt of court. The con- court has further observed that there is a clear cut distinction between a compromise arrived at between the parties or a consent order passed by the court. At the instant of the parties, at the instant of the parties, or consent order passed by the court at the instant of the parties and a clear and categorical understanding given by any of the parties. In the former, if there is violation of the compromise or the order, no question of contempt of court arises. But the party has a right to enforce the order or compromise by their executing the order or getting an injunction from the court. Where a compromise is arrived at between the parties and a particular property having been allotted to A, he has to be put in possession thereof by BB does not give possession of this property. So lot of cases available in our library and the online content, some of the PDF formats, lot of like this. I have collected lot of articles. For example, you just understand the articles and the cases. Then cases only elaborate the content. It shows you what are the examples. So you just go to read the cases. You got lot of points. So that is very important. So and then after that, I will explain for the criminal contempt. Criminal contempt. We are studying for that contempt of court. Another contempt, criminal contempt. In India, the definition of contempt of court is found in class C of section 2 of the Contempt of Court Act 1971. It provides that criminal contempt means the publication, whether by words spoken or written or by sign. So first you just understand the civil contempt and the criminal contempt. So first you just understand that civil contempt. After that we go to that criminal contempt. So now I will I will explain for that criminal contempt. In India, the definition of contempt of court is found in class of section 2 of the Contempt of Courts Act 9 in 1971. It provides that criminal contempt means the publication, whether by words, spoken, or written, or by sign, or by visible representation, or otherwise of any matter of the doing of any act. Whatsoever which scandalizes or tends to scandalize or lower or tends to lower the authority of any court or prejudices or interfaces or tends to interfere with the due to course of any judicial proceedings or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manners. These, these things are called criminal contempt. I explained that case in Delhi Judicial Services Association versus State of Gujarat and others, named 1991 for SEC 406 case. So the court held that the definition of criminal contempt is wide enough to include any act of a person which would tend to interfere with the administration of justice or which would lower the authority of the court. The scope of the criminal contempt has been made very wide. So, as to empower the court to preserve the majesty of law, which is an in, indispensable conditions for the rule of law. This is the first case. And another one case is in Hiralal Dixit versus State of UP, Air 1954, the Supreme Court, SE 743. In this case, the court held that to constitute the criminal conduct, it is not necessary that the publication or other act should have actually resulted in scandalizing or lowering the authority of the court or interference with the due course of judicial proceedings or administration of justice. The essence of the offense is that the act complained of are likely to result in scandalizing or lowering the authority of the court or interfere with the due course of judicial proceedings or administration of justice. The court further held that the law of contempt is deterrent in nature and it is concerned essentially with the prevention of scandalization of prejudice or interference with the due course of judicial proceedings or administration of justice, rather than merely applying sanctions to commit comments or acts which have scandalized or lowered the authority of the court or prejudiced or interfered with the due course of judicial proceedings or administration of justice. Thus, the offense of contempt is completed by mere attempt and does not depend on actual deflection of justice. These cases are also very important for our contempt of court classes in criminal contempt.